You asked him to be in court, and he will not leave this court. The court is sitting.
And you brought him yesterday.
And you don't do anything to it. This is like a democratic society. How does this young man? I now sit here with him.
Thank you. And we offer him solidarity.
Mask, it is a national obligation. Yeah, no. I'm an advocate out of this court, and I can tell you. Mimi sasa mmesha ni witnesses hapa. Simkuta tena. This fellas the way they are. And again, this person has a right to have an advocate. Mtu afanye utampiga. Angalia kijana anataka kupotea He has rights. Suspect. They will not harass this man in this court. Let him take the police station. Don't be biased.
I can take just a minute to step out.
So we give you a minute, yes? Okay.
Count 1, robbery with violence, according to section 2962 of the Penal Code, particulars of the offense, on the second day of June 2024 at Community Road in Wasarani County, Nairobi County, joined with others noted for court, road number 67839, Koplo, Jafford, Ogendo, battery of police communication gadget and a mobile phone with Samsung Galaxy Note 1 valued at Kenya shillings 50,000 shillings, and immediately before or immediately at the time of such robbery wounded the said number 67839 Corporal Jacob Ogendo. Ian Njoroge. Is it true or not true?
Honorable Kimaru, Honorable Mutuko said this, and I'm giving a copy to the court declaration. We are going to declaration and order. We hereby declare that section 296, 295, page, Your Honor, it's page 42 of 43. This is what the court said, High Court said, sitting in Nairobi and not even in Kisumu. We hereby declare that section 296, 295 and 296 to 297 1 and 297 2 of the Penal Code do not meet the constitutional threshold of setting out with sufficient precision, distinctively clarifying and differentiating the degrees of aggravation of the offense of robbery and attempted robbery with violence, such particularity as to enable those accused to adequately answer to the charges and prepare their defenses. They go ahead and say, in light of one above, we recommend that the Attorney General, the Kenya Law Reform and other relevant agencies to prepare detailed professional review in the context of judgment and order made in view of enabling Parliament to appropriately amend sections 295, 296, 1, 296, 2, 297, 1, and 297, 2 of the Penal Code with a view of removing the ambiguity. Walipewa nafasi waende waondoe dosari, lakini wakazembea kotini, wakazembea kazini. Maafisa wa serikali, they are now the same men preparing charges. And I don't know whether my sister maybe talk to the ODPP on this particular charge. This is what the court held recently. In view of the fact that there are pending trials before the court of various stages of hearing processes where the accused person has been charged with his two phones and a laptop, and these are good phones. they also took his ID, and because we do not expect them to conduct any forensic examination on these gadgets, they should return them like yesterday. The laptop HP-5 is a school gadget. It's a student that is in no doubt has produced documentation that should be given to him. Your Honor, on the submission under Article 29, I wish to add that this particular article is one of the articles under Article 25 that is not derogable. So that a policeman who has already characterized this young man as a dog is only expected to treat him as a dog when he has been given more time or once these court sanctions that they detain him long. Article 28, my Lord, Your Honor, is on the dignity. What my good colleague and brother has played here is very clear that they do not want, they just want more time to continue torturing this young man. When I was a student of literature, we used to call them this God is of you. Now, on to the first count, Your Honor. The first count, and then it has been put there maliciously. Robbery is violence, and we are going to demonstrate the particulars of malice. Your Honor, in Joseph Kaberia Karinga and 11 others versus Attorney General, 2016 EKRL, Your Honor, to be compensated for having been charged with a law that does not exist. Your Honor, the advocate who worked in this case happened to have been my friend, Evan Sultiki. Until this morning, when we learned that the police are concocting this particular charge, told me that they have not even bothered to apply under 5(2)B rules of the Court of Appeal to suspend this. So as you sit there, as we stand on this side, there is nothing like robbery with violence under section 296(2) of the Federal Code of Kenya. Watume maabara yao waende wakatengeneze sheria, waende wakatafute makosa mengine dhidi ya huyu kijana. Tafadhali tunaomba tunachokuwa tumwachilie huyu kijana kwa even on his personal bond, ile tunaita personal recognizance kwa lugha ya kikoloni ama Kiingereza. Tunakuomba tafadhali, hakuna sababu zozote ambazo zimetolewa. Tunaambiwa kwamba kulikuwa na umati katika kituo cha polisi mahali walipompeleka huyu kijana. Kama polisi wanaweza kwenda mtaa wote Nairobi wakiwa na vitoa machozi na kuwafukuza ama control the crowd, that is not a compelling reason. That in a police station like Kasarani or a police station like I'm told Kasarani Stadium, that the crowd prevented police officers with guns, with sniffer dogs, with tear gas, with handicaps, and with their very intimidating uniform to swear an affidavit. That, as my good friend submitted, is an admission of lack of seriousness. So therefore, Your Honor, if you are minded to release this young man on a cash bail, we pray that you disregard the first account because that should not count. That one is gone. The only thing that you should actually consider is if actually I don't think there is anything to consider. Admit him to flee personal bond. Aende nyumbani wakasome, wazazi wake wako hapa, si Tanzania, si Uganda, si Mkongomani, ni Mkenya ambaye anajua mahali yako. Usiwapatie mtu mwingine wote kwenda kumuita huyu kijana huko. Umesikiza na masikio yako wewe mwenyewe. Kwa hayo machache, kama una swali.
Is to be tendered by way of affidavit. That is our Evidence Act. Section 111 of the Evidence Act, Your Honor, says that he who avers must prove. The state has made wild allegations of crowds forming in police stations without any proof or pretense to that effect whatsoever. Your Honor, the accused person before you is 19 years old. He was brought here by 21 armed police officers. The number of police officers who escorted him are more than his age. These police officers, Your Honor, if they had time to sit down, they would have produced an affidavit before you. You cannot come to court 21 people to say that one individual will not sit down to craft a 5-page affidavit. He is a victim of state indolence, laziness, misconception of the law, and inefficiency in the police force. The state must not benefit from its inherent laziness. Having said that, Your Honor, I'll give you 2 authorities so that when you retire, you consider them. It is our trite law that when you are making an application to deny bail or bond, you give cogent evidence and not mere allegations. That was the position of the High Court sitting in Mombasa in criminal case number 26 of 2008. What the prosecutor has done is what the High Court warned, that mere allegations cannot deny an accused person his right to liberty and right to be admitted to bail. And lastly, Your Honor, when you look at the charge sheet, is a poorly crafted play that is to be watched by yourself and then be convinced that crimes of serious magnitude were committed. A 19-year-old robbing a mobile phone and a battery from an armed police officer. It's one of the worst plays to be played in our courts. In R versus Salim Said Nasoro, R versus Salim Said Nasoro, criminal case number 351 of 2016, in a High Court in Milimani, court was very clear that seriousness of the offense per se is not a reason to deny bail. Even if they are to charge him of murder or attempted murder, to make the offense appear serious before unsuspecting court users, it would not have been enough to deny him bail. Therefore, pray, Your Honor, that you consider the state, including the prosecution, not to have tendered anything before you, work determination, for the reason that there is no affidavit on record, even a poorly drafted one, to demonstrate that they lacked time to do a proper one, and proceed to have the charge sheet in its present ridiculous form read, and the accused person admitted to reasonable bail terms. Rest my case.
Those things that have been submitted on stipulation, and not to, for the court not to put reliance on the same. Also being the issue that we will sit for 3 days, then another 14 days, that is just mere speculation. You know what has been said by the three counsel, and I will tell you, is that Your Honor, there is need for urgent evidence for us to move the court in the application to Now what they're not telling the court, it has been decided that this can only come through an affidavit. I cannot make submissions from the bar seeking for position from you. And this is the very reason I'm before you when seeking time. I've been given reasons why the IO did not have time. It is reasonable. And also to dispute the fact that he was not arrested on Sunday, but yesterday, as reflected in the charge sheet. In fact, Your Honor, as to the issue of the affidavit, the defense are claiming even before you today that we do not even have an affidavit to the issue why we are used. Then it's an admission and it's clear that we do need an affidavit, which is the time we are seeking to put in support of our petition, so that once we are putting the affidavit, the issue of bond can be canvassed. On my next check that has been taken before you, where they are claiming they keep asking for it. The emotions, the display of emotions of one person does not speak for the entire National Police Service. And also, Your Honor, they were disputing the issue of crowd. Yet, to their own admission, they say the accused person has been brought to court by 21 persons. That is not normal. It's only circumstances that call for that is when there's the need for such a settlement. The state does not intend to be dealing with this person. We are here for a fair trial. We will be given that. Just pray for time to put in our affidavit. And lastly, to the issue of the charge of the very proud. So if there is any mistake to the charge, there is recourse under Section 214 of the CPC. And however, I am well informed by my co-counsel, Mr. Shoka, that there is a High Court petition ongoing regarding the same charges. And that will be very important. Due to the nature of the public interest that it has attracted, there was a lot of how to control investigation. The IO particularly received those factors just to find the matter yesterday. He had a very short time to report statements, seek the relevant staff reports, and also present the file to our office for consideration of registration of the charges. Therefore, he has not had time to take an affidavit in opposition of all, which is the position the state wishes to take. We are objecting to the person being granted bond. Mine is pray for 3 minutes. To allow the IO to put in the affidavit. So that's when the issues of bond can be canvassed.
Yeah, that's
taken aback by the application made by the prosecution this morning. Your Honor, this is the first time in Kenya's history that a court is being requested to declare that the inability of giving an affidavit or performing an affidavit by an investigation officer becomes one of the compelling reasons to deny an accused person bond. It has never happened. not even in Uganda. Your Honor, what is a compelling reason? Your Honor, is something that has been exhausted and has gone all the way to the utmost course. Not only has that happened, but even the bail-bond policy that my sister is guided, that is their Bible as a DOP, is very clear on what is a compelling reason. And the aspect that an officer has not been cannot be a reason for a court to detain, to order for the detainment of an accused person for even a minute longer, Your Honor. That will go into the history books. If this court, that is what you are being invited to do. And what will happen, Your Honor, if you allow that door? If you open up that door, Your Honor, I very respectfully submit. Your Honor, nothing stops all other investigating officers from always coming to this court and all other courts and abusing that and saying, we did not have time. Detain this person for 3 days. Now they're asking for 3 days, the next time they'll be asking for 14 days on that reason, which is not in our constitution, Your Honor. And Your Honor, I'm sure if it wasn't for the fact that my sister was called out, that's not a reason that she would have actually given. She was not prepared to oppose court. But someone has just called her, used this reason, unfortunately. But we are happy, Your Honor, that the Constitution empowers you to uphold the rights of even Lucifer himself or herself, I don't know the gender. If Lucifer was to stand on this particular matter, Your Honor, the Constitution still says that person remains innocent until proven guilty. And the right to bond, Your Honor, can only be curtailed when they have told you, even if it will have been off the back, that this person is at slight risk. Would not attend court. Can interfere with witnesses. I do not wish to regurgitate that, Your Honor, because you know it better than myself. And to that extent, Your Honor, it is our humble submission before you has been brought before you. Your Honor, there have been grave violations. Your Honor, within a second, I will just play a very small clip that has been posted by the police within 1 minute, just for you to understand what they are saying.
Until tomorrow, wherein we expect that they file the intended affidavit in position of accused person being released on court. So I'll give them 1 day, we'll come back tomorrow, and then we can argue that application tomorrow. More of it has been argued today, I must agree, yeah? But you can buttress it tomorrow once we have that affidavit. Because I think it's strike law, and I think you have rightly pointed out, without those cogent, very formidable grounds, the court cannot continue detaining the accused person. So let's wait until tomorrow we see that affidavit, and then we can argue the same tomorrow. So I'll not grant them the 3 days they are sought, I'll grant them only 1 day. So we'll come back tomorrow for that, yes.
Can we convene the same at 12? Because I know it has to be still taken to our office because of procedure. So in the morning they submit.
Your Honor, just one more thing in protection of the intended accused person, because he has not taken plea. Your Honor, this morning we had drama in this. He has taken plea. Sorry. In this morning we had drama in this court before you entered.
Okay.
The police officers who accompanied him attempted to assault him when he was seated with his advocate, and I had to physically intervene as his advocate. So as you send him back to them, Your Honor, favor us with a statement that his rights must be protected. His body has scars all over, and we are afraid that this 1 day you are granting them may make a difference.
Your Honor, just...
And they should take him to hospital for that matter.
Yes, as a follow-up, Your Honor, and actually that's what I wanted to mention. Your Honor, now that you have wisely given your directions, the accused person has injuries, as you've been told. And I don't know the aspect of the personal items, I don't know if we deal with them tomorrow, because you know you've taken...
Yeah, I think let's deal with them tomorrow. And also, maybe not, just to underscore, you know, that we have to protect his right as well. Yeah? So I think you've elucidated the content of Article 28, 27, and also the right of an accused person. Yeah. So I think for all the agencies involved, kindly let's adhere to our constitution. Yeah. So that it's not, we don't aggravate the situation as it is. I'm not allegedly aggravate the situation as it is. So let his right be protected. Let me hear from the other team whether on the issue of being escorted to hospital. Kenyatta. Okay. Escorted to Kenyatta, and then he should be accompanied by a parent, and also at all times he should be given access to his counsel, yeah, so that we can curtail or stop any form of an injustice towards him or infringement of his right. So then he'll be remanded at the industrial area. So meet tomorrow at noon then.
Thank you.
Okay.